All right, good morning, everyone. Welcome to the appellate court. I'm Judge Bright. I'm sitting this morning with Judge Albert and Justice Norcott. We're going to hear the case of Omar Miller versus Doe. The docket number is AC 43845. This argument is being conducted over the Teams platform. Everyone is appearing by audio and video except for Mr. Miller, who's appearing solely by audio. Are you comfortable with doing that, Mr. Miller?
Yes, I am.
Okay. So what I'm going to do, because we're doing this remotely, I would just want to make sure everyone can hear everyone okay. So I'm going to ask everyone to introduce themselves. We'll start with the judges, then counsel for the appellant, and then the appellee, and then we'll get started. Again, I'm Judge Bright.
I'm Judge Alford.
I'm Justice Norcott.
Good morning. This is Assistant Attorney General Janelle Medeiros for the appellant, Mr. Medina.
This is Omar Miller for the plaintiff appellee.
All right. I can hear everyone okay, and I can see everyone okay, except for Mr. Miller, of course. So I will assume that's true for everyone else. If at any time you're unable to hear anyone, or if anyone's unable to see anyone that they can currently see, please let us know. If you get disconnected, we will pause the argument until we get everyone back on. I would ask that everyone, when you're not speaking, that you mute your microphones to avoid any background noises. Each side will have 20 minutes to argue. Mr. Miller, you can reserve some time for rebuttal. Mr. Miller, can you see us or can you only hear us?
I can only hear you.
Okay, so I will let you know during your argument when you have 5 minutes left, when you have 2 minutes left, and when you have 1 minute left, okay?
Okay.
All right. Attorney Medeiros, are you ready to proceed?
Yes, Your Honor. I would ask to reserve 5 minutes for rebuttal.
Okay, I will keep the time. And for you, Attorney Medeiros, I will hold up signs at 2 minutes and at 1 minute and when your time is up.
Thank you, Your Honor.
Okay, may proceed.
Good morning, Your Honors, and may it please the court. My name is Janelle Medeiros, and I represent the defendant appellant, Officer Medina, in this matter. This court should reverse the decision of the trial court and enter judgment in favor of the appellant for 2 reasons. First, the trial court erred by failing to properly analyze the defendant's qualified immunity defense. And second, a proper analysis indicates that the defendant is entitled to qualified immunity. Ultimately, the question of whether the defendant is entitled to qualified immunity comes down to a simple, pure question of law before this court. Whether it was clearly established on July 13th, 2013, that a motor vehicle accident involving an inmate could amount to a constitutional violation. The answer to this question is a resounding no. In order to get to that answer, we have to do a review of the case law that was in existence at the time of the incident, which again was July 3rd, 2013. And in doing so, we have to look to see if there are any controlling cases with facts that are particularized and similar to the facts of the instant case that render it so clear and so obvious that any reasonable official in the defendant's shoes would know that what he was doing violated the plaintiff's constitutional rights. And while there's, a lot of different case law about what exactly that means, it really can be distilled down to a simple question for this court in this circuit, which is there a Second Circuit or a U.S. Supreme Court case that has held that any motor vehicle accident involving an inmate can rise to the level of constitutional violation, as at the time of the incident here, which was, again, July 3rd, 2013. We don't have that. To date, neither the plaintiff nor the trial court was able to identify such a case because none exists. There hasn't been a Second Circuit or Supreme Court case that has ever held that an inmate can sustain any type of constitutional claim based upon a motor vehicle accident. The closest case that we have that even discusses motor vehicles of any kind and inmates is the Jabbar versus Fisher case, which the plaintiff points to in his brief. But that case just doesn't work for the clearly established analysis for qualified immunity for a few reasons. First, in Jabbar, the holding of the case is actually adverse to the plaintiff and helps the defendants here. The holding of the case in that in that case was that it's not constitutionally required to have seatbelts on prison transportation buses. So not only was the holding not that a lack of seatbelts is a constitutional violation, but also just the facts of that case are not similar, are not particularized, and similar to the facts of this case. We didn't have an accident, we didn't have speeding. In that case, the inmates weren't even restrained as we had in the case here. We don't have a crash. All we had before the Second Circuit there was a single question, which is, are prison seatbelts constitutionally required on a prison transportation bus? And the answer was no.
So, Attorney Medeiros, so let's say we have a case that comes up in Connecticut that the Second Circuit hasn't addressed yet, but which we conclude the Second Circuit would clearly find that this was so egregious that there's no entitlement to government immunity. Are you saying we can't reach that? Prison guard says, you know what, I'm going to drive 120 miles per hour and I'm going to swerve back and forth and knock you guys around, and I hope you die. We have to wait for a Second Circuit decision that says, no, that's enough?
Well, Your Honor, I mean, there is a line of qualified immunity cases like Your Honor is referring to where, it's something that's so bad that you don't need a case from the Second Circuit or a Supreme Court case on point. The perfect example and the case that's often cited in those types of cases, the Hope versus Peltzer case, the whipping post case, right? I can say there certainly is a scenario that we can think of involving a motor vehicle and inmates where it would be so egregious and so terrible that you don't need a specific case on point. But that's, this is not that case. We're not talking about a case with someone driving 120 miles an hour and demonstrating.
Well, Counselor, where do you draw the line?
I don't think that the court needs to draw a line here. It's just not necessary in this case because we don't have allegations of speed at that point, but there certainly is a line. I don't think that the court needs to identify it today, but there certainly must be a line at some point where, yes, it's so egregious that you don't need a case to for example, another example, if we had a case where an officer purposely drove down, hit a pedestrian inmate with his car. That's probably a case where we would not be arguing you need a Second Circuit or Supreme Court case that says you can't run over somebody with your prison vehicle, or if someone were strapped to the towing package of a vehicle and dragged down the street. Obviously, those are ones that would be so egregious that we wouldn't need a case. But that line of cases with the you don't need a case line of cases, very rarely used. The Supreme Court does not use that exception to clearly established very often. Neither does the Second Circuit, because there have not been situations that are so bad that you don't need a case. Even in criminal conduct, even in cases involving criminal conduct, the Second Circuit has required a case on point. For example, the Crawford versus Cuomo case in the Second Circuit, that case involved allegations of criminal conduct, criminal sexual assault of inmates. And the Second Circuit still said there, no, our prior precedent was not clear enough. This wasn't so bad that you wouldn't need a case. You did need a case, and there wasn't one. So here we're not talking about criminal conduct necessarily. We're not talking about a whipping post or hitting an inmate with a vehicle or 120 miles an hour. So I don't think that the court needs to draw that line here. I think all that this court needs to do is look at the existing case law in 2013. And not only did we not have a Second Circuit case or a U.S. Supreme Court case on prison motor vehicle accidents, but looking at out-of-circuit cases and district court cases at that time just does not demonstrate that every reasonable officer would think what they were doing was unconstitutional. So at that time, the only circuits that had considered prison motor vehicle accidents were the 10th, the 7th, and the 8th. And the 10th Circuit had said such claims don't rise to more than the level of negligence and granted qualified immunity for an officer. That was the Dexter case out of the 10th Circuit. And in the 7th Circuit, in the Alexander case, the 7th Circuit said, nope, car accidents don't rise to anything more than negligence. You can't sustain a constitutional claim, even if you're an inmate. The 8th Circuit in the Brown case had held the opposite, but it was really the outlier at that time. The 10th and the 7th that had addressed it went the other way. And if we look at district court cases within the Second Circuit at that time, not a single district court case within the Second Circuit before July 3rd, 2013, had held that an inmate motor vehicle accident could give rise to a constitutional claim. In fact, it was the opposite. At least eight, I believe it was eight district court cases had held that inmate motor vehicle accidents could not rise to more than negligence. And the facts of those cases are described in a footnote in the plaintiff's reply, or in the defendant's reply brief at page 6. Some of those district court cases involved allegations that were arguably worse and more egregious than the ones that we have here. And given that, and given just the entire purpose of qualified immunity is to ensure that every reasonable officer would understand that what they were doing was unconstitutional, at that time, not even every reasonable judge agreed that that conduct was unconstitutional. So it's impossible to say that it was beyond debate that this gave rise to a constitutional violation in 2013.
Attorney Medeiros, you make the point that the trial court did not apply the proper test. Do you agree, although I'm sure you disagree with the conclusion Judge Elgo reached, do you agree that Judge Elgo, in denying the motion to dismiss, applied the proper test?
Well, Your Honor, I think that in denying the motion to dismiss, yes, the court conducted a detailed analysis under the clearly established prong. However, I think that as Your Honor noted, the outcome was inaccurate. I think what the court did was held that the reference to the Eighth Circuit Brown case in the Jabbar prison seatbelt case was enough to clearly establish law. And that's just an incorrect conclusion. There's significant case law from the Supreme Court and the Second Circuit saying that dicta cannot clearly establish law. It would have had to be the holding of Jabbar that could clearly establish the law in this case. And as we've noted, the facts in Jabbar were not particularized to the facts of this case. So essentially, in denying the motion to dismiss, it seems like there was a reliance upon a citation to Brown, an Eighth Circuit case in Jabbar, to clearly establish law, which is just that wouldn't be supported by the current qualified immunity law. Dicta cannot clearly establish law. As the Supreme Court said in the District of Columbia case versus Westby, it isn't enough for the Second Circuit or the Supreme Court to just hint or suggest at a particular outcome in a future case. It has to be a holding in a case with similar factual circumstances, and that Jabbar is not that. So Jabbar can't act to clearly establish the law here.
What about the evidence that there were regulations in place here, or procedures in the manual that were violated by the defendant?
Your Honor, I think that is an important fact when we're looking at the merits of the claim, but it's not material for the qualified immunity analysis and the clearly established analysis when we don't have a case that talks about motor vehicle accidents or motor vehicle policies and procedures at all, really, other than the Jabbar case from the Second Circuit or the Supreme Court. If we had a case from the Second Circuit or the Supreme Court that said something along the lines of, it had similar factual circumstances, but the speed were different, or maybe there were icy road conditions and that amounted to a constitutional violation, we might not be making the clearly established argument here, or maybe certain facts that the plaintiff has brought up would be material, but we don't even have a case about motor vehicle accidents at all from the Second Circuit or the Supreme Court.
Yeah, but you've already conceded that you don't need a case from the Second Circuit on motor vehicle accidents if it was so egregious. So then the question becomes, is there a factual issue as to whether this conduct could be considered so egregious as to avoid qualified immunity? And there is evidence that that the defendant was driving over 60 miles per hour, or approximately 60 miles per hour in a 35 mile per hour zone?
Yes, Your Honor.
And there was evidence that the plaintiff asked to be put into a vehicle where he could fit and be properly secure, correct?
Yes.
And there's evidence that the procedures were violated, right?
Yes, Your Honor.
So why don't all of those create a genuine issue of material fact as to whether this was so egregious as to defeat qualified immunity.
Well, Your Honor, again, well, first, just for the court's reference, none of these facts are disputed. There are no disputed facts at this point. Everything that Your Honor just listed off, the defendant did not dispute those facts. But
well, I think you dispute the speed he was going.
Well, yes, Your Honor. I think it was. The defendant does not dispute that he was driving in excess of the speed limit. The degree, whether it was 40 or 60, that's unclear. Whether it's entirely supported by evidence or not in the record, and whether it was brought up below is, a different issue. But in terms of whether those facts create a disputed issue as to whether this is so egregious that it could be, you don't need a case like the whipping post case. Again, as I noted before, that's an exception to the clearly established analysis, and it's very, very rarely used. There have been cases with conduct that is extremely egregious, much worse than the conduct that we have here. As I noted before, criminal conduct involving sexual assaults of inmates in the Crawford case, or in the Mullenix case, intentional use of a weapon by a state trooper shooting a passenger and killing the victim. There, the court didn't say this is so egregious that you don't need a case, or a complete lack of suicide protocols in the Taylor versus Barks case. Cases where the injuries were particularly egregious, the conduct was particularly egregious, and the court said, no, this is not so bad as to be a Hope versus Peltzer case. That's not what we have here. And in fact, in many of the cases at the time of this incident, within this circuit and without the 10th Circuit and the 7th Circuit, in all of those cases where the courts had said, either granted qualified immunity or said this doesn't rise to more than negligence, the facts were at least as bad as what we have here, if not worse. In some of them, there were all of the same factors that we have here, and additionally, inclement weather or statements of intent, which we did not have here. As the plaintiff said in his deposition, the defendant never indicated that he wanted to hurt the plaintiff or did this on purpose. As he said it best. He said, I don't think that the defendant was paying attention. This happened because he wasn't paying attention. And that boils down to what we have here. And I see my time is up, so I would just say we would ask the defendant the defendant respectfully request this court reverse the decision of the trial court and find the defendant entitled to immunity.
All right, thank you. Mr. Miller, you'll have 20 minutes. You ready to go?
Yes, Your Honor.
Okay, go ahead.
All right. This is Mr. Omar Miller for the plaintiff appellee. And at the outset of this case, I want to say that the defendant is not entitled to qualified immunity because he violated plaintiff appellee's right to be free from cruel and unusual punishment. And I would like to point out that the Constitution is a living and breathing document which guarantees all Americans protection on the rights guaranteed therein. In this case specifically, plaintiff's Eighth Amendment right to be free from cruel and unusual punishment is at issue. Today, our appellate court has the opportunity to decide whether the United States Constitution breathes life into plaintiff's claim of his Eighth Amendment violation right being violated, or rather that defendant Josh Medina, aka John Doe, or rather that the Constitution has its eyes closed to defendant Medina's actions on that day on July 3rd, 2013. Estelle versus Gamble, and that's Estelle versus Gamble, United States Supreme Court 429 U.S. 97, punishments which are incompatible with the evolving standards of decency that mark progress of a maturing society, which involve unnecessary or wanton infliction of pain are repugnant to the Eighth Amendment of the United States Constitution. The question before this case, the question before this court today is, did defendant Josh Medina subject plaintiff to unnecessary and wanton infliction of pain? To establish a violation under the Eighth Amendment, first the objective requirement is that did plaintiff have a right to be free from cruel and unusual punishment, and and whether or not that he had an expectation of reasonable safety. The second prong deals with a subjective state of mind. In this case, I want to point out the facts in regards to the things that are the issues that are in dispute first. Defendant Medina did not attempt to get another vehicle when plaintiff told him that there wasn't enough space for him to sit upright in the car, and that's in plaintiff's appellate brief 023 at 15. The defendant disputes that, and then another dispute. Plaintiff claims that it wasn't seat belted. That's in plaintiff's brief on page 3. The defendant claimed that he does not recall. Another dispute is that the defendant drove in excess in a reckless manner. A material fact that the defendant disputes by saying that he says that I was traveling at approximately 40 miles per hour. The speed limit was 30 miles per hour. The defendant's statement is indicative of his belief that he was adhering to the speed limit, although defendant's counsel says that now, we're not disputing he probably was going at 60 miles per hour. Basically, she's trying to play both sides of the fence so that the court could rule in her favor as whether or not these facts are in dispute. As a result of defendant's erratic driving in excess of the speed limit, he crashed into the rear end of a motorist's vehicle. Consequently, plaintiff was injured, and he had knocked unconscious, head was bleeding, and had contusions amongst the whole host of bodily injuries. That's plaintiff's brief 5. Defendant.
Mr. Miller?
Yes.
Mr. Miller, I'm sorry if I could interrupt you. I wanted to ask you a question.
Yes.
You mentioned that there is evidence in the record that you'd requested another vehicle, that you couldn't sit up straight, and you were told to lay on the seat. Was there anything in the record that reflects that you expressed a concern as to safety as opposed to comfort?
Yes, that wasn't a comfort complaint. When I was talking to the individual at that time, I told him that I couldn't protect myself in an event of a crash. That's why we had dialogue in relation to getting another vehicle, and he gave me a direct.
So can you point to and I know you are probably at somewhat of a disadvantage, but can you tell us generally where in the record that was? Was it in an affidavit? Was it in your deposition testimony? Where could we find that reference to you expressing a concern about protecting yourself?
I believe it's in my deposition. In the deposition.
Okay.
And I would like to point out. I would like to point out that in regards to the dialogue is whether it's safety or comfort. It wasn't a matter of comfort being that. Pardon me. It can be also implied from the fact that I told him there's no space in here for me to sit up correctly between the seats because there was a partition between the front seat and the back seat, which would not allow me to be able to sit up. And in such a condition, I would be vulnerable to an accident. So perhaps maybe we didn't go over that dialogue on through the deposition, but that is what is indicated through my argument of saying, please get another vehicle, that I don't feel safe. And furthermore, that it should be pointed out that it's in the record that I requested discovery in regards to the videotape which shows this altercation. However, through legal argument and tactics by the defendant, they made an argument as to whether or not this the tape was safety and security, and the request for discovery was denied in that regard. But that tape could have pointed that out in regards to the back and forth with me and our defendant about the safety in this vehicle. And And
Thank you, sir. You can continue with the argument.
Okay. And the defendant disputes the injuries that he claims that he checked on plaintiff, but plaintiff had no visible injuries that he could see. That's in the plaintiff's brief, page 6. And it's also, you can see the pictures that are attached into the attached into the plaintiff's brief in relation to that. The defendant claims that this wasn't so an egregious act, and that basically the plaintiff could have did anything. The plaintiff could have just took the defendant. Pardon me. Basically, Medina could have just took the prisoner and put him in the trunk and just drove around the city and crashed into a wall, and that would have been all right, based upon the defendant's argument and her perception of what is so bad and what is not. Obviously, her perception in regards to these facts are based upon her own opinion, and it doesn't seem to be reasonable it doesn't seem to be reasonable in regards to our consciousness and our morale in today's society with the ever-evolving standards of decency. At the beginning of this case, before this crash took place, defendant Medina had a job to do. He's an officer of the law. He is trained specifically on how to protect himself as well as how to protect inmates, because the Eighth Amendment has been clearly established that people that are working for the state or whoever are required to treat individuals with a certain amount of dignity, and they have to provide reasonable safety, in addition to all the other protections such as medical care, food, clothing, and shelter, which is not an issue in this case. Reasonable safety is the issue. In this case, the defendant did his job. He cuffed me up, and he cuffed me up with my hands to my waist, put the shackles on, and then proceeded to put me in that car, which was the issue. I told him this car is too small. It's not enough room in the back of the seat. Please get another car because I'm gonna be vulnerable back here. Defendant gave me a direct order, said please lay down on the back of the seat, and just shut the door and proceeded to drive crazy and reckless. He did the same thing on the way back from the hospital, and then he crashed into the back of a car because he was speeding, and he did not care. Now, as far as the subjective state of mind is concerned, any individual who drives a car, has a license, knows that, one, you must, in all states across the United States, especially in Connecticut, you must have a seatbelt on. The Department of Corrections Administrative Directive 6.4 states that you have to, in certain vehicles, that you have to put a seatbelt on an inmate. In this particular vehicle, the defendant was required to put a seatbelt on me, but he ignored that when he ignored that after having a dispute already about the fact that I couldn't sit up in the back of that car, which would indicate that he would not be able to seatbelt me anyway. So he knows basically right then and there that when he laid me down in the back of the seat that he would not be able to put a seatbelt on me, and that lack of seatbelt would subject me to any type of force because the rules any type of force from turning or whether crashing, I would be subject to danger because I wouldn't be able to protect myself because the way that I was cuffed up and things of that nature. Now, in regards to Jabbar versus Fisher and the ruling in that case, the Second Circuit says that a failure to provide a seatbelt not in itself, that meaning that you can't just by itself providing an inmate a seatbelt does not raise constitutional issue without more. What is the more? The more is driving recklessly or erratically, which was pointed out in the Brown versus Fortney case, holding that driving recklessly while transporting shackled inmate without seatbelt, despite requests to slow down, constituted unreasonable and substantial risk of harm, violating the Eighth Amendment. My case is similar to that in the sense that I did not have a seatbelt on. There was a directive that required for a defendant to put a seatbelt on me. And the request to slow down in my situation could be tantamount or comparable in the sense that I told him that I'm not safe in this car. Please get another vehicle. And that was something that could be done. And the defendant states that he did not have the authority to get another car, which also is unreasonable in nature, because anytime an officer has a problem, he has to report to his superior. So if he has any type of problem, only thing he has to do is take a pause, make a phone call. Hey, the prisoner says that this car is too small, so forth and so on. We have an issue. I'm not able to place a seatbelt on him as required by Administrative Directive 6.4. Under the law, we cannot subject this prisoner to cruel and unusual punishment. I think that driving in his car with him under these conditions, he may get hurt, especially if I crash. Not to mention just the turns and the sharp turns, dipping and out of traffic, going around the corners, and so forth and so on. So,
Mr. Miller, can I ask you
yes.
another question?
Yes, you may.
Is there any evidence in the record that you indicated that if he didn't get a new car, you just weren't going to go?
No, because as I pointed out in the trial brief, that one, I'm under when an officer is when an officer gives an inmate an order, he has to follow that order. In this case, we have to look at the context of the situation. Is that I was going to a medical appointment. As we know in Connecticut and throughout the prison system in the United States, that medical is a serious issue. These are not things that you could just put off sometimes. And in my case, I was going for a serious medical condition regarding my right ear. To put off the trip, to say I'm not going would subject me to another set of facts which could have caused harm to my health. So at that time, I was basically under duress to have to accept the officer's order, as well as to look out for my own personal well-being and my health and safety in regards to my physical condition. So I was not in a mental space, or as well as in a space of where I had authority to say that no, I'm not going to this appointment to them.
All right. Thank you for your response. You have about 4.5 minutes left.
Okay. All right. Yes. So I would like to point out too the distinguishing facts as defendant's lawyer pointed out, and hopefully Professor in regards to the whipping post. She's stating that the whipping post, basically she conceded that was something that seemed to be egregious. However, the whipping post, the inmate in that case, he was not whipped or anything. He was cuffed to a whipping post in conditions that they thought it could be harmful to this inmate, because it was real sunny out there and he was left for hours out there and he was dehydrated. The injury resulted from the conditions and the weather and things of that nature. So in that regard, it wasn't reasonable. And I juxtapose that to my case, that under the conditions and the circumstances in this case, it was not reasonable for defendant Medina to cuff me up, then force me into a vehicle that he knew was too small, that he knew didn't have a seatbelt in it, and then drive in excess of the speed limits in a reckless manner and crash into the back of another vehicle, which resulted in injury to myself. And that's where I leave off my case. Was it reasonable? Was it reasonable for defendant to do these things and to subject me to unreasonable wanton infliction of pain and suffering? And my answer is no. And in regards to the rulings of the court, the defendant had counsel for the defendant had other legal options as far as getting a ruling of having the court articulate the ruling in a more pleasing manner. She did not do that. We have rules in the Connecticut Rules of Court for articulation and rectification. She did not do that.
You have 2 minutes,
However,
Mr. Miller.
excuse me?
You have 2 minutes left.
Okay. However, she did not move for a motion for articulation nor rectification. I believe it's based upon the fact that the trial court, Judge Elgo, had already articulated the legal basis and set out the facts for the ruling, and that Your Honor, Mook Washer, I don't know if I'm saying his name right, Mook Washer later on just reiterated what the lower court stated. So in that sense, I don't believe that the defendant has a legal leg to stand upon, and I rest with that.
Okay, thank you very much, Mr. Miller. Attorney Medeiros, you'll have 5 minutes for your rebuttal.
Thank you, Your Honors. So I just want to address three things very briefly, but preliminarily in response to your question, Judge Bright, I know Mr. Miller may not have the appendix in front of him, but the court can find the plaintiff's testimony about the discussion he had with the officer at the beginning at page A-282 in the defendant's appendix that has all the testimony about the conversation when they first got into the car there. So first, I just want to address the plaintiff mentions the quote from Japar that a lack of prison seatbelts, quote, without more does not give rise to a constitutional violation. And again, as I mentioned in my primary argument and as is explained in the brief, as the Supreme Court has said multiple times, most notably in the District of Columbia versus Westby case, a hint or an implication or a suggestion that there may be a certain ruling in a future case is not enough to clearly establish law. Dicta cannot clearly establish law. So again, that statement, which is not the holding, which doesn't have to do with the facts of the case, which is really at best dicta and a hint or an implication at a future holding, is just not enough to clearly establish. And second, I just want to address the, again, what we were talking about previously with the Hope versus Peltzer so egregious exception there. Typically in those types of cases, we're looking at a situation where there is silence, almost complete silence on the issue that's being evaluated in the case. And it's so egregious that, you know, we wouldn't need a case anyway. In most of the cases where it's been held, oh, it's so egregious you don't need a case, there also has been silence on the issue generally. We absolutely do not have silence here. What we have is we have two circuit court cases with similar facts, the 10th and the 7th, that have said this is nothing, this is not a constitutional violation, or the defendants get qualified immunity. And we have 8 district court cases within this circuit with similar and worse facts saying these are not constitutional violations. And on top of that, we also have general statements of tort law and 1983 law from the U.S. Supreme Court, Second Circuit, and all the courts across the country saying car accidents are typically described as the paradigm of a tort claim, not a constitutional claim. And, you know, the Supreme Court said in Peratt, they held out automobile accidents as a perfect example of something that should not be a 1983 claim. So given all of those statements and the existing case law, we don't have silence on the issue. We have a lot of case law at the time in 2013 that would suggest that it is not clearly established and likely did not give rise to a constitutional violation. And lastly, I just want to point out that the defendants are not trying to diminish the plaintiff's injuries here. They're not arguing that the defendant's conduct was not inappropriate. and might not even, and may even give rise to a constitutional violation. We're arguing that it wasn't clearly established. We're not arguing that the plaintiff should be without a remedy. To the contrary, there are remedies available for this type of claim for motor vehicle accident. There's negligence claims, there's claims before the claims commissioner. There's actually a statutory waiver of sovereign immunity for state-owned vehicles with section 52-556 for car accidents. There's also state recklessness claims. There are remedies available, but the plaintiff has pursued a specific type of claim, a federal constitutional claim pursuant to 1983 for money damages. And that type of claim comes with a specific type of immunity, federal qualified immunity, which would not be available as a defense to the defendant in a state law claim or a negligence or a recklessness claim. By allowing this claim to proceed as a federal 1983 claim, it would really be elevating what should be appropriately brought as a tort claim to the level of a constitutional violation, which is exactly what qualified immunity is designed to prevent. So I see my time is almost up. So unless the court has any further questions, the defendant urges the court to reverse the decision of the trial court and find that the defendant is entitled to immunity.
All right, I see no further questions. Thank you very much. I want to thank both of you for the arguments. The case is very well briefed on both sides and well argued. We'll take the matter under advisement, and we will stand in recess while we convene in the courtroom for our next two cases. Thank you.
All right.
Thank you.
So I'm done for today, and just wait for the ruling.